Encyclopedia Topics. Introduction. Psychology and Psychiatry. What is the difference between forensic psychology and forensic psychiatry? The straightforward answer is to say that forensic psychology is practiced by those who have first qualified as psychologists, that is MSc Psychology and PhD Psychology, then trained at postgraduate level to develop the necessary specialist competencies. Forensic psychiatrists, on the other hand, have first qualified in medicine, that is MBBS, then taken further professional training to qualify as psychiatrists, that is MD Psychiatry, or PG Diploma Psychiatry, or DM Psychiatry, with a forensic specialty. In practice, forensic psychiatrists hold statutory powers and responsibilities, such as prescription of medication and supervision of patients. Those powers and responsibilities are generally not given to other professions, including psychology or forensic psychology. Several distinctions can be made between forensic psychology and psychiatry. First, psychiatrists are trained to think in terms of abnormalities in an individual's biological and medical functioning. Psychologists do not have this specific focus, but are trained to consider personality, behavior, and broader social dimensions to explain an individual's behavior. Second, psychiatrists tend to draw their professional knowledge from clinical observation and research with clinical samples. Psychologists rely more heavily on systematically gathered experimental data. Third, psychiatrists lean towards assessment of individual clients through clinical interview and observation. Psychologists are more likely to use psychometric and other psychological tests. The similarities between forensic psychology and psychiatry lie in a shared concern with the broad fields of crime and antisocial behavior. However, given the variations in professional training and methods, there are some distinct contrasts in the work of the two disciplines. Traditionally, forensic psychology has its roots in the application of psychological knowledge and expertise to gather evidence for judicial purposes. It is a case that this traditional use of the term forensic is closest to the dictionary meaning of the word. For example, the concise Oxford Dictionary entry in forensic gives of or used in courts of law. However, within psychology, the meaning of the term forensic has broadened considerably in recent years to encompass not just the courts but any topic connected with crime and law. Thus, some texts on forensic psychology cover subjects such as police, treatment of offenders, risk assessment, theories of criminal behavior, which adhering to the dictionary definition are not forensic strictly. Ronald Blackburn, a leading British psychologist, has criticized this redefining of the term forensic to cover any psychological activity vaguely connected with law. Blackburn's case is that without a meaningful definition of the term forensic, and the dictionary supplies the best understood definition, a profession that calls itself forensic psychology struggles to find an identity. Without a professional identity, we are left with the question of what are the unique skills and abilities that the forensic psychologist can offer. The root of the issue, of course, is that the term forensic psychology has metamorphosed from a description of an application of psychology to describing a kind of psychology. In keeping with the traditional sense and correct use of the term forensic, discussion of forensic psychology will be limited here to the application of psychological theory and knowledge to courts of law. Historical development. Forensic psychology. It is generally taken that forensic psychology dates from 1896 when Albert von Schrenck-Notzing appeared as an expert witness in Munich court, offering testimony at the trial of a man accused of murdering 3 women. The specialist acknowledged that von Schrenck-Notzing, a student of Wilhelm Wundt, who in 1879 founded the first psychological laboratory at the University of Leipzig, was able to put before the court was based on experimental psychological evidence on the workings of memory. Specifically, von Schrenck-Notzing argued that the memory of the witness to the crime being used as evidence in court was unreliable because the witnesses had become confused between their own memories for the event and the pre-trial publicity. The application of psychological knowledge and methods to the process of law attracted some of the great figures in the history of psychology, including James Cattell and Alfred Binet, while in the early 1900s other psychologists such as G.F. Arnold and Hugo Münsterberg were up and coming specialist forensic psychologists. The greatest of the early luminaries was another of Wilhelm Wundt's pupils or students, the German psychologist Hugo Münsterberg. His timing is 1863 to 1916. In his book On the Witness Stand, published in 1908, Münsterberg argued that developing discipline of psychology could be of benefit to the process of justice. These potential benefits, Münsterberg claimed, lay not only with the application of psychological knowledge of the working of memory to the veracity of the eyewitness, but extended to other matters such as working of the jury. Münsterberg made the case for psychologist's role in the courtroom as an expert witness to inform the process of justice on matters psychological. Münsterberg's arguments drew fierce attack from some quarters of the legal profession, that is lawyers, anxious to resist the foray of psychologists into the courtroom. Nonetheless, the spread of psychology in the courtroom continued. In France, in early 1900s, Alfred Binet worked on the issue of reliability of eyewitness memory, and in 1921 in America, psychological testimony was used in court to argue the case that a victim's testimony was doubtful because of his or her low intellect. After the Second World War, the profession of psychology grew in sophistication with the establishment of specialist educational and clinical psychologists. At first, these newly emerging specializations provided psychological material for inclusion in medical court reports. However, as time passed, psychologists were permitted to submit court reports in their own right, rather than have their work subsumed into a report written by another professional doctor. As the discipline of psychology progressed from 1950 to the present day, so psychologists gave their attention to an increasing range of courtroom issues. Importantly, the role of psychologist as an expert witness developed considerably. Several surveys and summarized in Table 1 showed that the psychologists now were to testify in court on a range of topics. Let us see Table 1. The typical subjects found in UK psychologist court reports are 1. PTSD, post-traumatic stress disorder of the victim. Compensation. Third is child care. Fourth is suitability for treatment. Fifth is fitness to plead or fitness to stand trial. Sixth is reliability of witness statements. Seventh is reliability of confessional evidence. Eighth, diminished responsibility. These are sourced from Gudjonsson, G.H. 1996, Psychological Evidence in Court. Results from 1995 survey. It is in the magazine The Psychologist. Psychologists were also cultivating a research agenda that would impact on two areas of forensic psychology. First, research that would lead to greater levels of understanding with respect to reliability of evidence. Second, research that would increase dramatically the level of psychological insight into law, its provisions and its application in the courtroom. Forensic psychiatry. Heading. If the discipline of psychology has a short history, most often traced to the beginning in the Wundt laboratory, as noted above, quite the opposite is the case for forensic psychiatry. The medical profession, of which psychiatry is a branch and forensic psychiatry a specialty within that particular branch, has a long history. Indeed, the medical historian Roy Portner traces the evolution of medicine to the end of the last ice age, around 10,000 to 12,000 years ago. As the organization of societies shifted from hunter-gatherer to farming in order to sustain life, Porter suggests that the transmission of pathogens from animal to human led to an explosion in diseases such as tuberculosis, smallpox, measles, and typhoid. As the population settled together in ever greater numbers, so the spread of parasites such as worms, flukes, and lice increased. Similarly, changes in diet as agriculture became the mainstream of food production brought about conditions related to low protein intake and other dietary conditions. Thus, population growth and change in societal structure heralded the onset of epidemics such as plague. As history unfolds, each evolutionary shift brings its benefits but also takes a toll on health. The Industrial Revolution brought prosperity to some as well as illnesses caused by pollution. The demands of modern day living are associated with stress related conditions such as hypertension and excessive use of drugs and alcohol. As illness and disease took their toll in terms of human suffering, so people tried to find ways to heal the sick, and with the advent of healing, so medicine was born. The historical record shows that throughout antiquity, civilization developed their own understanding of the causes and cures of illness. The great civilizations including Babylon, ancient Greece, Egypt, India and China have all left records of their theories of illness, their medical practice and even their surgical tools. As history unfolds, so important advances were made. We see, for example, improved understanding of human anatomy, appreciation of the complexity of disease, discovery of new drugs, and technological progress from microscopy and X-rays to brain scan and microsurgery. Thus, the treatment of physical illness has roots that reach back to the very beginning of civilization. It is long recognized that there are some people whose illness is of a special type. Madness was as familiar to the ancient Greeks as it is to contemporary society. However, there was no special branch of medicine dedicated to relieving the suffering of the mad, whose treatment and care was left to families and communities, or, if at all else failed, to mad houses run by charities or religious groups. It was not until the mid 18th century that psychiatry began to appear as a specialized branch of medicine. The rise in the use of asylum for insane across much of Europe and later America has heralded the involvement of the medical profession with those suffering from mental disorder. The treatment of those people held in asylums was not always gentle. Shock treatment, confinement, purging, and physical restraint were common practices in the struggle to find a cure for insanity. The great pioneers of psychiatry, including Benjamin Rush, 1745 to 1813, Henry Maudsley, 1835 to 1918, and Emil Kraepelin, 1856 to 1926, set in train a change of thinking emphasizing the need for medical understanding and treatment of the mentally disordered. The influence of such innovative thought, coupled with growing social reaction against the conditions in the asylums and the discovery of treatments such as psychoanalysis for mental disturbance, culminated in the birth of psychiatric hospitals. While present-day enthusiasm for care in the community has led to a diminishing role of the psychiatric hospital, it is nevertheless the case that many people with mental disorder are cared for in psychiatric hospitals only. So, it transpired that the mentally ill became the property of the medical profession. As psychiatry found a professional identity, so psychiatrists were seen as the experts on the assessment and treatment of mental disorders. In law, the insane have traditionally been accorded a special status, in that it is accepted that they should not be punished for criminal acts. The reasoning behind this status is plain. The concept of mens rea holds that if a person is to be held responsible for his or her actions, then it must be the case that in committing a crime they have acted of their own free will. Can it be said that the mentally ill are responsible for their actions, including criminal acts? These are two legal cases which were highly influential in formulating an answer to this question. James Hatfield, 1771 to 1841, was a soldier in the Duke of York's bodyguard who received sabre-inflicted head wounds while fighting in the Battle of Linselles, Flanders, in 1794. From the accounts of the case, it is evident that Hatfield must have suffered brain damage, which in turn precipitated bouts of mental instability. It was said that during these bouts of insanity, he would threaten the life of his child because God so commanded. He would also say that he must die to save the world, yet he must not kill himself. An individual making such a presentation would now be seen as exhibiting delusions following his or her head injury. Hatfield devised a plan that would bring about his death. He would assassinate the monarch, King George III, for which the penalty would be execution. In 1800, he made his attempt, firing a pistol at the king as he entered the theatre. His shot missed and Hatfield was captured by the bystanders, charged with high treason and eventually brought to trial. Alongside the growing awareness of the time of plight of the mentally ill, Hatfield's case attracted widespread public sympathy, particularly given his standing as a British soldier wounded in battle. During Hatfield's trial, his defense delivered by Thomas Erskine, sought to refine the argument and with respect to legal standing of the individuals with a mental illness. Erskine could not apply the so-called wild beast test, as Hatfield was clearly lucid and able to comprehend the court proceedings. Instead, Erskine used a more subtle approach, advancing the argument that Hatfield's delusions at the time of offence must be taken into consideration. If the court agreed that Hatfield was deluded at the time of assassination attempt, then Erskine argued he cannot be considered guilty of a crime. Medical and lay evidence was called upon to support the defence's position regarding Hatfield's madness. Erskine's strategy worked and the Lord Chief Justice halted the trial, directing the jury to find Hatfield not guilty, he being under the influence of insanity at the time the act was committed. The judgment had two important consequences. First, It created a new class of offenders then called criminal lunatics, now generally referred to as mentally disordered offenders. Second, it created a practical problem. If Hatfield was not a criminal, then it would be followed that he could not be sent to jail. Nonetheless, if Hatfield was judged to be a danger to the public, some form of secure detention was required to protect society. As will be seen presently, the solution to this dilemma was an important one in the development of forensic psychiatry. However, turning to the second important legal case, the name the actor Daniel McNaughton, spelt McNaughton. In some text, name comes to the attention. The case of Daniel McNaughton, 1813 to 65, is generally taken to be the beginning of mental health legislation in England with regard to criminal acts. The name of McNaughton is variously spelt in different sources. When it appears as McNaughton, McNaughton, as in the original trial report, McNaughton and McNaughton, as in the records from the Bethlehem and Brandmoor hospitals. While the family spelling was McNaughton and the other one known, for example, of McNaughton's signature, supports the spelling of McNaughton. On the basis of the case records dating back to 1840s, it is highly likely that McNaughton was suffering from paranoid schizophrenia. Specifically, he believed that he was being persecuted by both Catholic priests and the Tories. His delusional beliefs led him to the decision that to end his prosecution, he would try to kill Tory Prime Minister Sir Robert Peel. In 1843, McNaughton made an attempt on the life of the Prime Minister, but through mistaken identity, shot and killed the Prime Minister's private secretary. McNaughton was arrested at the scene of the crime and sent for trial. The weight of eminent medical opinion at the trial was that McNaughton was insane and the jury returned a verdict of not guilty on case of insanity. However, McNaughton's insanity was not a florid type leading to obvious loss of control. It was clear from his own statement that he knew very well that he was doing at the time of crime, acted deliberately and was fully aware of his actions and their consequences. Despite McNaughton's plea that he was driven by his prosecution, it was calculated quality of the seemingly cold-blooded killing that brought about a war of public protest after the trial. Accordingly, leading judges of the day were asked to inform the government on the interpretation of laws of the last land with regard to legal position for cases of insanity and crime. The judges formulated the McNaughton test or McNaughton policy, as they are sometimes called. The McNaughton test, given several caveats, embodies several key principles. First, everyone who stands before a court is to be presumed sane and responsible unless proved otherwise. Second, an insane person is punishable. Loss of control. It was clear from his own statement that he knew very well what he was doing at the time of crime and acted deliberately and was fully aware of his actions and their consequences. Despite McNaughton's plea that he was driven by his persecution, it was the calculated quality of the seemingly cold-blooded killing that brought about a wave of public protest after the trial. Accordingly, leading judges of the day were asked to inform the government on the interpretation of the laws of the land with regard to the legal position for cases of insanity and crime. The judges formulated the McNaughton test or the McNaughton rules, as they are sometimes called. The McNaughton test, given several caveats, embodies several key principles. First, everyone who stands before a court is to be presumed sane and responsible unless proven otherwise. Second, an insane person is punishable if he or she knew at the time of the offence that the act was wrong. Third, to establish an insanity defence, it must be proved that at the time of offence the accused did not know the nature of the act, or if they were aware of their actions, that they did not know that their actions were wrong. Thus, to establish an insanity defence, the test is, does the accused know the nature of the act? If the accused does know the nature of the act, do they know it is wrong? These are powerful questions demanding special skills and knowledge to provide answers. Some members of the medical profession of the day began to specialize in understanding the criminal lunatic so as to inform the courts on just such matters. As the courts began to grapple with the implications of the cases such as Hatfield and McNaughton, the issues they raised were not just legal but were also practical in nature. If such people were not criminals, could they be sent to jail? If they were judged to be dangerous, could they be released into the community? The judge in the Hatfield case did send Hatfield to jail, but expressed doubts about his authority to do so under the law of the land. Thus, a series of parliamentary acts dating from 1800 onwards began to put in place legislation to allow criminal lunatics to be admitted to asylums for the mentally ill. Hatfield was taken from jail and admitted to Bethlehem Hospital in London, but he was not a model patient. He killed another patient and escaped from the hospital, spending time at large before his recapture and return to Newgate Jail. This type of incident led to the view that asylums were being asked to admit patients for whom the facilities, personnel, and buildings alike were not suited. This concern led to the development of hospital criminal wings. These wings were secure with locks, bolts, and bars, but staffed by doctors and nurses to treat those detained. In 1816, Hatfield was admitted to the criminal wing at Bethlehem Hospital, where he remained until his death in 1849, when he was 70 years of age. However, by the late 1850s, further concern was expressed about the level of security and safety in these wards and the standard of treatment which they offered. Thus, in 1860, building of Broadmoor Criminal Lunatic Asylum in Berkshire began. Broadmoor opened in 1863 and began receiving its first patients, decanted from the criminal wings of hospitals to fill its 500 beds. Broadmoor was the first of a series of high-security institutions for the criminal lunatic. Rampton Hospital followed in 1914. Then Moss Side in 1933, and finally Park Lane in 1974, the latter two being amalgamated in the 1992 form Ashworth Hospital. Carstairs Hospital in Scotland performs a similar function, also accepting patients from Northern Ireland. Legislative changes gave these institutions the generic title of Special Hospital, and they are charged with detaining mentally disordered offenders under conditions of maximum security. Moving to recent times, a new wave of services has developed which offer treatment for mentally disordered offenders in setting of medium and low security as well as in the community. As services expanded, so the importance of understanding and treating the criminal lunatic group and the specialism of forensic psychiatry developed accordingly. The growth in forensic expertise can be seen in the increasing refinement of mental health law, academic study of the relationship between the mental disorder and criminal behavior, specialist assessment of the individual to inform the court, risk assessment of the danger posed by an individual, and the growth in sophistication in design, running, and evaluation of services for the mentally disordered offender. Similar developments are to be seen in North America and many other countries. Current practice. Forensic psychology. What expertise might a forensic psychologist be able to offer the court with respect to the evidence placed before it? First, the psychologist can present the findings of empirical psychological research on the strengths and weaknesses of different types of evidence. For example, there is a body of research on both eyewitness evidence and confessional evidence. Second, the psychologist may give an expert assessment on a given case. Lionel Howard has described 4 roles that the forensic psychologist might take while acting as an expert witness. Number 1, actuarial role. In this role, the forensic psychologist draws on statistical information to give evidence regarding the probability of an event. For example, psychologists may provide actuarial evidence regarding the sequelae of a psychological trauma and its impact on social functioning. Next, advisory role. Second, the psychologist may provide an opinion before or during the trial on another expert's report, advising on the accuracy of the report and which issues to focus on when the report's author is under examination. Third, clinical or assessment role. In this role, forensic psychologist presents the court with evidence regarding the individual state of mind, as with, for example, the presence of a psychological disorder or a dysfunction. Howard extends this role to include the assessment of normal human functioning. For example, Goodjohnson and Howard note a case in which it was important to establish that the accused was left-handed, and findings from a series of observational, neurological, psychological tests were used to present evidence to the court regarding this matter. Experimental role. The credibility of evidence presented in court may hinge upon whether the human performance under given conditions is likely to be accurate to the level required by the court. Could a witness have really seen a face under low level of light? Is it possible to make accurate judgment of another car's speed when traveling in a moving vehicle? Such questions are open to experimental investigation by simulating the conditions at the time of incident and testing performance, thereby giving the court an empirically informed statement of the reliability of evidence in a given case. Next, forensic psychiatry. The role of forensic psychiatrists in court, although reflecting a different professional perspective, may be identical with those defined by Harvard for the forensic psychologist. Thus, forensic psychiatrists might draw on the research on the relationship between mental disorder and criminal behavior to inform a given case. Alternatively, a forensic psychiatrist might be called on to give an expert opinion on respect to the individual's fitness to stand trial, or formulate a risk assessment with regard to, say, releasing a patient from secure conditioning into the community, or to inform the court with respect to the treatability of an offender. Concluding comment. While there are differences between forensic psychology and psychiatry, the complexity of the issues involved mean that when the two disciplines come together, alongside other professions like forensic nurse, probation officer, and the police, they are in their most effective avatar. Encyclopedia. Glossary. Actus reus. The guiding principle in law, which dates back to the jurist Sir Edward Coke, when deciding if a crime has taken place, is that an act does not make a person guilty unless their mind is also guilty. Actus reus, which literally means guilty act, is the external element of a crime and is taken to be a bodily movement. The internal element of a crime lies in the intent of the actor to do wrong, the guilty mind, or mens rea. Next, DSM. DSM full form, the Diagnostic and Statistical Manual of the Mental Disorders, is published by the American Psychiatric Association. It presents standard criteria for a classification of mental disorders and is used in the USA and other parts of the world by academic researchers, clinicians, health services, insurance companies, and policy makers. A text revision of DSM-4, DSM-4-TR was published in 2000 year, which gave additional diagnostic information. Mens rea, literally guilty mind. Risk assessment, the process of estimating or using actuarially derived parameters or professional judgment, the likelihood or risk of an event occurring. Risk factors, the variables that predict the likelihood of a given criteria of a risk occurring. Now, forensic psychiatry in full. The subject matter of forensic psychiatry lies in the application of psychiatric knowledge to the offender population with respect to the juxtaposition between mental disorder and criminal behavior. The majority of offenders are not mentally disordered. However, some offenders, generally called mentally disordered offender or MDO, do have a diagnosable mental disorder, and this group is of partial concern to forensic psychiatry or particular concern to the forensic psychiatry. The starting point in discussing mental disorder and crime lies in the legally acceptable definition of mental disorder. In general psychiatric practice, a mental disorder is diagnosed by reference to the formal diagnostic system, such as the American Psychiatrist Association Diagnostic and Statistical Manual of Mental Disorders, that is DSMMD. For the purpose of this law, however, a legal definition of the term mental disorder is required. For example, in England, the Mental Health Act 2007 states that the type of mental disorders to be considered by the court in criminal cases are mental illness like schizophrenia, bipolar disorder, anxiety or depression. Then personality disorders and eating disorders, autistic spectrum disorders and learning disabilities. However, a brain disorder or disability is not taken to be a mental disorder unless it also gives rise to a disability or a disorder of the mind. It is also the case that the new types of disorder can be introduced. The advent of dangerous and severe personality disorders was an initiative aimed at those whose level of violence, including sexual violence, posed a significant danger to the community. There are 2 points to note with regard to the mental health legislation. First, legal definitions may vary by location. In other words, different jurisdictions may well have different definitions of mental disorder. Second, definitions of mental disorder do not remain constant over time within the same jurisdiction. In England and Wales, in 2007 Act made some significant changes in the preceding 1983 Act. The shifts and changes in definition of the term mental disorder for legal purposes also introduced an element of discord with the formal psychiatric diagnostic system, which themselves may change according to the time and place. The net result of these variations is that in a given case, forensic psychiatrists must work with the courts in deciding upon the issue of mental disorder. The overlap between the mental disorder and the criminal behavior has concerned criminologists, lawyers, psychiatrists. For many years, for a crime to be committed in law, there must be two elements, mens rea and actus reus. The former may be thought of as an intention to commit an act while knowing it was wrong, the latter to be thought of as a failure to act or a negligent act by itself. Thus, the act is committed unless there can be shown to be mens rea or guilty intent. There is no criminal case to answer. The obvious example of principle in action lies the notion of an agent of criminal responsibility. A child may commit a serious act, which we accept that because of their age they cannot legally be held responsible for their action and so cannot be said to be a committed crime. In other words, for those not just to be responsible for their action, there can be said to be an actus reus but not mens rea. Since the trial of Daniel McNaughton, the law has evolved to take account of the view that the mentally disordered or mad cannot be said to have mens rea and therefore cannot be held responsible for their action. It is intrinsic to the fairness of legal system that it does not penalize those members of society such as children and the age of criminal responsibility who are not aware of the consequences of their actions. An individual who is mentally disordered within the legal understanding of that term may fall into the category of those for whom mens rea is absent. When mens rea is absent, the individual cannot be said to have committed a crime and is accordingly dealt with under the mental health legislation rather than criminal law. It follows that the imposition of sanctions that may ordinarily follow a crime such as imprisonment are not appropriate for the mentally disordered individual. The court may order that a mental disordered offender receives a treatment which, depending on the risk the individual poses to the wider community, is to be delivered in various settings ranging from community to low, medium or high security. From the wide range of concerns of forensic psychiatry, these areas have been selected for discussion as they encapsulate issues at different legal stages with regard to the mentally disoriented offender. These three are 1. Assassination of competence prior to commitment. 2. Risk assessment with respect to placements. 4. 3. Treatment during placement. Assessment of complexities. Assessment of competence. The present difficulty in the case of mentally disordered offender lies in establishing whether at the time they committed the act the accused was aware of the action and if so whether they knew that the act was wrong. In cases of mental disorder it falls to the defense to mount an insanity defense, that is to plead that the accused is in fact not guilty by reason of insanity at the time the act was committed. Then are variations to this theme across different legal systems. However, the task of forensic psychiatrists remains broadly to see in such cases. That is, psychiatrists must look hard at post-predict rather than predict to give a professional opinion of the accused state of mind at the time of crime. Given that there may be months or even years between the act and the need for a psychiatric prospection, it is clear that such assessments can never be an exact science. The overlap between mental disorder and criminal behavior has concerned criminologists, lawyers, psychiatrists for many years. For a crime to be committed in law, there has to be two elements, mens rea, guilty mind, actus reus, guilty action. The former may be thought of as an intention to commit an act, knowing that it is wrong. The latter as the act or a failure to act as in negligence itself. Thus the act may be committed, but unless there can be shown to be mens rea, guilty intent, there is no criminal case to answer. The obvious example of this principle in action lies in the notion of age of criminal responsibility. A child may commit a serious act, but we accept that because of their age they cannot legally be held responsible for their action and so cannot be said to have committed a crime. In other words, for those not just to be responsible for their action, there can be said to be actus reus is there, but no mens rea. This is the triad of Daniel McNaughton. The law has evolved to take account of the view that the mad or mentally disordered cannot be said to have mens rea and so cannot be held responsible for their action. It is intrinsic to the fairness of legal system that it does not penalize those members of society, such as children under the age of criminal responsibility, who are not aware of the consequences of their action. An individual who is mentally disordered within the legal understanding of the term may fall into the category of those for whom mens rea is absent. When mens rea is absent, the individual cannot be said to have committed a crime and is accordingly dealt with under the mental health legislation rather than under a criminal law. It follows that the imposition of sanctions that may ordinarily follow a crime, such as imprisonment, are not appropriate for the mentally disordered individual. The court may order that the mentally disordered offender receives treatment which, depending on the risk the individual poses to the wider community, is to be delivered in various settings ranging from community at low, medium or high security. From the wide range of concerns of forensic psychiatry, these three areas have been selected for discussion as they encapsulate issues at different legal stages with regard to the mentally disordered individual offender. The three topics are assessment of the competence prior to committal, second, risk assessment with respect to placement, and three, treatment during placement. Assessment of competence. In practical difficulty in case of mentally disordered offender lies in establishing whether at the time that they committed the act the accused was aware of their actions, and if so, whether they knew that their act was wrong. In cases of mental disorder, it falls to the defense to mount an insanity defense, that is, to plead that the accused is in fact not guilty by reason of insanity at the time the act was committed. There are variations on this theme across different legal systems. However, the task of the forensic psychiatrist remains broadly the same in such cases, that is, the psychiatrist must look back, post-dict rather than predict, to give a professional opinion of the accused's state of mind at the time of the crime. Given that there may be months or even years between the act and the need for psychiatric post-prediction, it is clear that such assessments can never be an exact science. While the moral and legal issues are similar with respect to competency to stand trial, variously referred to as unfit to plead or under disability, the practical task facing the forensic practitioner, psychiatrist, lies in the present rather than the past. In England and Wales, for example, the legal test of fitness to plead is that the accused is unable to comprehend the course of proceedings of the trial so as to make a proper defense, to know that he or she might challenge any jurors, and to comprehend the evidence or give proper instruction to his or her legal representatives. It falls to the forensic psychiatrist to inform the court whether the accused is mentally disordered within the legal meaning of the term. There are several protocols that have been developed to aid assessment of competency, such as competency screening test and Georgia court competency test. It is unlikely, however, that these instruments will replace the traditional clinical skills of the forensic psychiatrist. Risk assessment. A risk assessment is an exercise in prediction, an estimation of the likelihood that some future event will occur. The estimation of risk is required in many areas of life. Financiers estimate the risk of their investment, insurers estimate the risk of fire, theft and car accident, and surgeons estimate the risk of operations. When sanctioning the treatment of a mentally disordered offender, a prime concern lies in the risk of the offender poses to the community. Is it safe to allow the individual to attend a local hospital to receive the necessary treatment, or is the risk too high that they will inflict further harm on others? If there is a risk of harm, what level of security is required? In making decisions about this type of risk, much is at stake. Should the individual reoffend? Of course, continued offending includes both the human cost endured by further or future victims and the financial cost of being associated with the police, courts and so on. In this light, the assessment of the risk posed by the mentally disordered offender is highly important. As shown in table 1 above, in practice, forensic practitioners are faced with a classic decision outcome matrix: actual yes, actual no, predict yes, predict no. That is the 4 boxes. Actual yes and predict yes, then true positive, that is a hit. Predict yes, then actual no, then it is a false positive, that is a miss. Actual yes and predict no, that is a false negative, that is a miss. Actual no and predict no, that is a true negative, that is a hit. There are 2 hits and 2 misses. To illustrate the process involved, consider the processes in making the decision whether or not to send a violent, mentally disordered person to a maximum security hospital. It is the role of practitioners to predict whether the level of risk of that person being a continued danger to the public is such as to justify detaining the individual for treatment in conditions of high security. Suppose the psychiatric predicts yes, and indeed had the individual stayed in the community there would have been more victims, actual yes. Then a decision to admit to a hospital is correct, that is a hit, and the public will be protected. However, suppose the prediction is yes, but in fact the individual would not have been a continued danger to the public, actual no. Now the person will wrongly be admitted to conditions of security, that is a miss, with all the attendant issues with respect to human rights and public spending. Alternatively, suppose the practitioner predicts no, and the person is not detained but then commits further serious offences in the community, that is an actual yes. Such instances, a miss, are highly likely to attract the popular media, and the scene is set for a public inquiry. Finally, the prediction may be no, and the individual remains in the community and does not reoffend, actual no, which is a good decision, that is a hit. It is in favor of the person. These same processes repeat themselves as other times in the mentally disordered offender's route through the secure system, as for example, at the point of making decisions about an individual's release from high security to less secure conditions. The terminology of risk assessment. The criteria of risk is a basic term in risk assessment. It refers to an exact description of the event that is being assessed. For example, in physical medicine, the criteria of risk might be the occurrence of heart disease or cancer, even a particular form of illness like angina or a breast cancer. Once the criteria of risk is set, then in order to estimate risk in a given case, the associated predictors or risk factors must be identified. Thus, for the criterion of heart disease, the predictors may include a family history of heart disease, a history of smoking, a pattern of unhealthy eating and lack of exercise, a high cholesterol level, high blood pressure, and a stressful occupation. It is important to emphasize that the presence of these predictors does not mean that the realization of the risk is inevitable. Rather, the presence of a predictor increases the likelihood that the event will occur, recognizing that some predictions carry more weight than others. Further, it is generally the case that the greater the number of extant predictors in a given case, the greater the risk becomes. Thus, an individual with a family history of heart disease who smokes 20 cigarettes a day and has high blood pressure is more likely to suffer a heart attack than another individual who has a moderately high cholesterol reading. The important word here is likely, for neither of these individuals is a heart attack certain, but the risk would certainly be seen as higher in the former compared to the latter. The identification of the predictors of risk is not a simple task. The issue facing practitioners is how to know exactly what aspect of an individual history and current functioning should be of concern in order to estimate a given risk. The research literature traditionally makes the distinction between static predictors of risk and the dynamic predictors of risk. Static risk predictors are historical or background factors, the presence of which is known to elevate the risk of a given criteria. In the example above, a family history of heart disease would be a static risk predictor for heart disease. Again, the presence of static predictors, which by definition cannot change, does not mean that the event is predetermined. The presence of static predictors simply raises the probability of the event happening in the future. Dynamic risk predictors are aspects of an individual's current functioning, thus smoking, unhealthy diet, a stressful job are all dynamic risk factors in relation to heart disease. In practice, it is often a combination of static and dynamic predictors that gives the strongest basis by which to predict risk. In summary, when completing a risk assessment system, it is critical to have a clearly defined risk criteria. Once the risk criteria are set, the appropriate risk predictions can then be identified and a method of assessment put into place. Methods of risk assessment. The classic distinction with respect to the method of risk assessment lies in clinical and actuarial practice. Clinical prediction. In clinical prediction, the assessment of risk is based on professional judgment by an individual practitioner, a clinical team, or a case reference. The accuracy of the prediction relies on the clinical knowledge and experience of those involved. Next, actuarial prediction. Actuarial risk prediction using statistical methods to identify the risk factors for a given criteria. The statistically identified risk factors may then be combined into an algorithm to produce a standardized risk assessment, typically in the form of a questionnaire that guides the assessor through the necessary steps to arrive at an assessment of risk. In developing a system of actuarial risk assessment, the first step is to identify the risk predictors for the given criteria. Initially, though, the use of clinical records, case material, and research literature, potential risk factors are identified for the criteria of concern. Second step, is to identify an appropriate cohort and measure all the previously identified potential risk factors. The cohort is then followed by over a lengthy period of time, typically years, to establish which potential risk factors actually best predict the occurrence of the criterion of risk. Now the table 2, actuarial predictors. 1. Level of victim injury to the index offence, never married, number 2. Number 3. Female victim index offence. 4. Failure on prior conditional release. 5. Property offence history. 6. Age at index offence. 7. Alcohol abuse history. 8. High score on psychopathy checklist. 9. DSM-3 personality disorder. 10. Separation from parents under age 16. 11. Victim injury in index offence. 12. DSM-3 schizophrenia. These factors are contributive to recidivism. That is, their presence suggests that the violent recidivism is less likely. A good example of actuarial to risk assessment is seen in all the research conducted in Canada concerned with the development of a scale for assessing the risk of violent recidivism or mentally disordered individuals, offenders. The cohort in this study consisted of more than 600 males treated in a maximum security psychiatric hospital. After a mean time at risk of almost 7 years, the cohort was divided into those individuals who were not violent recidivists. These two groups could then be compared across a range of demographic, clinical, and offence-related measures with the aim of determining statistically what particular factors differentiated between the two groups and hence predicted violent recidivism. As I told in table 2 earlier, 12 predictors of violent recidivism were identified using statistical methods. These factors are efficient in that they maximize the likelihood of making a hit and minimize the likelihood of a miss. In order to make the research available for clinical practice, Christopher Webster and his colleagues produced the violence prediction schema to be used in assessing the likelihood of violence by high-risk men. The violence prediction schema presents practitioners with full details on assessing the variation in predictors and producing the estimate of a risk of violent recidivism. This instrument is designed for use with high-risk men and therefore so it should not be used with other population, say women or young offenders, where quite different predictors of violence may be involved. The same procedure can be followed for other criteria. Sex offending is mentally disordered population is an obvious concern, and actuarial studies have identified several predictions of sexual recidivism. Another Canadian study by Vernon Quincy and his colleagues reported that rapists presented a greater risk of recidivism than sex offenders against children. As shown in table 3, they identified a range of predictors of sexual offending. Range of predictors of actual sexual offending are 1. Never married. 2. Violent convictions. 3. Admission to corrections. 4. Previous sexual conviction. 5. Previous female victims. 6. Previous male child victims. 7. Deviant sexual interest. 8. High score on psychopathy checklist. It is Quincy by actuarial predictions. There are now a great deal of research conducted on actuarial risk assessment with mentally disordered offenders, enabling increasingly fine-grained and sensitive assessments to be made. This research has led to development of instruments such as classification of violent risk and historical clinical risk management -20. There is a long-running debate regarding the relative efficacy of clinical and actuarial prediction. Those who favor actuarial methods note the scientific basis and superior accuracy of statistical prediction. Proponents of clinical methods argue for the skill of the clinician in making individually based risk assessment and against extrapolating from broad-based research findings to the individual patient. Treatment and mentally disordered offender. Alongside court work, the treatment of mentally disordered a mainstay of forensic psychiatry services. Such services can be delivered to the community, in hospitals both open and secure, and in prisons. The task of those offending treatment to the mentally disordered offender is complex, alongside an awareness of risk to the public, and in some cases the need to work within conditions of security. Treatment has twin aims of ameliorating the disorder while also lowering the risk of offending. It is not always the case that these two aims are synonymous. Take for example the case of a person with schizophrenia prone to angry outburst and associated act of violence. The treatment must both reduce the symptoms of schizophrenia and help the individual learn to control their anger in order to reduce the risk of violent behavior. In practice, the treatment may well involve a combination of psychotropic drugs to treat the schizophrenia and psychological methods to address anger and violent behavior. The Violent Offender Treatment Program provides an example of this approach. Violent Offender Treatment Program. The VOTP was designed for mentally disordered offenders in high security and uses a combination of individual and group work or therapy set against the background of medication inappropriate for each patient. After a comprehensive assessment using the patient's files, clinical interview and observation, and psychometric scales, patients begin the program. In order to learn to control their anger and violent behavior, patients learn first to analyze the situation that leads to them to become angry, and then learn strategies to manage their thoughts and emotions, and develop skills to communicate and negotiate more effectively so as to reduce interpersonal conflict. The evaluation of the VOTP program indicates that it is successful in bringing about change. Conclusion. While relatively few in number compared to mainstream offenders, the mentally disordered offender is of great public concern and sets many challenges for forensic psychiatry. The complexities of the moral and legal issues with respect to responsibility, the intricacies of assessment, and the problems of treatment are all issues that are sensitive to changes in law, social policy, and clinical practice. This article is over. The suspect's formal admission of guilt under conditions of duress. There are two types of coerced false confession. 1. Coerced compliant, where the suspect makes a confession knowing that it is false. 2. Coerced internalized, where during interrogation the suspect comes to believe that the official version is correct and their own memory is wrong. Cognitive interview, a method of interviewing the witnesses that uses prompts and retrieval techniques based on the psychology of memory. Next, error of commission. An error of commission occurs when a witness mistakenly introduces into their testimony something which they did not see at the time of the incident. Error of omission. An error of omission occurs when a witness fails to recall something they had observed at the time of the incident. Interrogative suggestibility. Suggestibility is the extent to which an individual is compliant with commands, instructions, or orders from another person. High levels of suggestibility, as with hypnotic suggestibility, are not common. Interrogative suggestibility refers to the degree to which people will come to accept as true the messages conveyed by the interrogator during formal questioning. Leading question, a question that has the potential to mislead a witness by presupposing the answer or by providing misleading information. Mock jury study, an experimental methodology intended to replicate and so allow the study of the process which takes place when a real jury is deliberating in a criminal trial. Forensic psychology. At the turn of 20th century, a number of pioneers including G.F. Arnold, Guy Whipple, and Hugo Münsterberg began exploring the potential of applying emerging psychological knowledge to the workings of the legal system. Indeed, as long ago as 1908, Hugo Münsterberg set the agenda for future generations of forensic psychologists in nominating the reliability of evidence and the workings of the courtroom as the main concern of forensic psychology. Since that time, forensic psychology, sometimes called legal psychology, has become a specialty in its own right, although maintaining a central concern with evidence and the courtroom. The psychology of evidence, eyewitness testimony. The involvement of psychologists in understanding the intricacies of eyewitness testimony provides an example of the interplay between psychological theory, applied psychological research, and real-life decisions in the courtroom. The fallibility of human memory lies at the heart of a catalogue of wrongful convictions influenced by eyewitness testimony. While the pioneers raised the issue, it is research from 1970s onward which has greatly enhanced understanding of the factors that may influence the accuracy of eyewitness memory. The functioning of human memory can be conceived as having three stages. First, the perception of acquisition of the information about the world. Second, storing or retaining the perceived information. Third, the process of retrieval or remembering the stored information. In the context of witnessing an incident, three stages become 1. Seeing the incident. 2. The period before giving evidence. 3. Giving evidence. As can be seen in Table 1, a range of factors are related to the accuracy of eyewitness memory, including both recall and what happened and facial identification of the suspect. Further, within these three stages, there are different kinds of variables to consider. These variables can be classified as social and others to do with interaction with people, and situational, that is, concerning the setting in which the event occurred. Individuals as with the characteristics of the individual witness, and interrogational, that is, regarding the process of eliciting information. The following sections provide examples of the way in which the research has investigated the influence of different variables at each of these three stages. So, now variables in eyewitness memory research: social or attitudes, and then situational or complexity of the event, individual or age, interrogational or artist sketches. So let us see in totality: social, attitudes, conformity, prejudice, status of the interrogator and stereotyping. Situational variables are complexity of the event, duration of the event, illumination available, time delay, type of crime, target factors and weapon. Individual variables are age, alcohol use, cognitive style, personality, race and sex. Interrogational are artist sketch, computer image, ID parade, mugshot, instructions, photo fit and training. Acquisition, nature of the witnessed incident. The effect on memory of the nature of the witnessed incident has been investigated in several studies which consider the impact of witnessing an incident which is violent in nature. As seen in a study reported by Elizabeth Loftus and her colleagues, such violent incidents may include scenes of physical assault and the presence of weapons. In the Loftus study, separate groups of observers saw different versions of a filmed bank robbery. In one version, shots were fired, but no one was hit. In another version, a small boy was hit and was seen bleeding from a head wound. Those witnesses who saw the violent scenes got less accurate recall of the incident. Such finding has been replicated in several studies, leading to the broad conclusion that memory is significantly better for the non-violent rather than violent incidents. However, it is likely that the degree of violence is important. Less threatening event that engage the witness's intention in a stimulating manner may produce satisfactory memories for the event. Further, there is a phenomenon of weapon focus, where witnesses' attention is directed at the knife and gun to the exclusion of other details about those involved and what happened. Next is retention, discussion between witnesses. In instances where there is more than one witness to the incident, should witnesses be allowed to discuss events before giving their testimony? The research evidence suggests that the group discussions can lead to a more complete description of the event, but at the price of introducing a source error. While having the potential to prompt memory and lead to fuller recall, discussions can also bring about errors of commission. That is, errors may be introduced which are related to items which are not seen in the original incident. Further, group dynamics may influence witnesses to change their testimony to agree with other members of the group. On balance, it is a moot point whether discussion between witnesses is desirable in the interest of producing an accurate testimony. Next is retrieval, leading questions. A body of research, perhaps most notably influenced by the American psychologist Elizabeth Loftus, has shown how even the most subtle changes in a question wording can influence witness testimony. Another study by Loftus and her colleagues provides an excellent example. Witnesses to a filmed automobile accident were asked to give estimates of the speed of the vehicle when they bump into each other. Different groups of witnesses were asked the question with the verb being one of contacted or bumped or hit or smashed. The witness estimates of the speed increased following the order given from 31.8 to 40.8 miles per hour. Further, when later requisition, the witnesses who had been asked about the smash were more likely to erroneously say that there was broken glass at the scene of the accident. Witnesses can also incorporate misleading information into their testimony. In another study by Loftus, observers are asked to judge the speed of the car as it passed the barn. Although no barn had been seen 1 week earlier, 1 week later, the observers were asked a set of questions about the film, including whether they had seen a barn. More than 17% of the primed observers said they had seen the fictional barn. The effect of misleading information are most likely to be found when the source of information is seen to be of high status, or if the witness thinks the police have special knowledge about the incident, or if the misleading information relates to peripheral detail rather than central event. Witness factors. Witness factors such as age, intelligence, personality, anxiety, and sex are active across all three stages of memory, although the research evidence does not suggest that they have any consistent effect on the accuracy of the eyewitness memory. However, there are two exceptions to this general conclusion. The first is the evidence regarding the relationship between the witness confidence and accuracy, which suggests caution in that confidence in the accuracy of one's memory is not an index of accuracy. The second is the body of work on children as witnesses, which shows that with sensitive, age-appropriate questioning, even young children can be reliable witnesses. Confession evidence. If a person confesses to a crime, this surely is an admission of guilt that is beyond dispute. While people unconnected with a case do come forward and make a voluntary false confession, the police investigation often shows beyond doubt that such admissions are fake, although a great deal of police time may be wasted investigating this type of confession. Voluntary false confessions are sometimes given by people seeking attention or who are psychologically distressed. On other occasions, suspects will knowingly give a false confession, called a coerced compliant false confession. During police interrogation, they may do this to free themselves from the stress of interrogation or to protect another person. Such false confessions are given in the sometimes mistaken belief that the police investigation will inevitably show that their confession is untrue. In the examples given thus far, the individual, unless severely disturbed, is aware that their confession is false. The phenomenon of coerced internalized false confession is seen when the suspect's own knowledge of the truth actually changes during interrogation, so that they come to agree with the interrogator's version of what happened. How can such a transformation in memory take place? In order to understand the coerced internalized false confession, it is necessary to consider the characteristics of both interrogation and the suspect. The forensic psychologist Gisli Gudjonsson has played a significant role in helping to understand the processes that produce false confession. Gudjonsson suggests that suspect under interrogation is taking part in a highly unusual closed social interaction. Interrogation occurs in a closed room. The suspect is closed off from all their normal surroundings and the suspect's attention is closed in on the interrogator. Further, the interrogator holds the balance of power and therefore controls all aspects of the interaction. Trained as in interrogational techniques based on the psychology of persuasion, the interrogator's focus is on gaining a confession from the suspect. Gudjonsson suggests that some suspects will cope with the stress of interrogation by actively dealing with the situation and resisting the pressure to confess. However, other suspects will become passive and take a helpless stance, seeking to avoid confrontation with the interrogator and reducing their emotional stress. Suspects who react in this passive way may be overly suggestible with regard to the interrogator's persuasive tactics. The concept of suggestibility has a long history in psychology. In 1900, Alfred Binet wrote Law Suggestibae. Since then, books and journals articles on topic have regularly appeared in the psychological literature. In context of an interrogation, interrogative suggestibility is the extent to which people will come to accept as true messages conveyed by the interrogator during formal questioning. Thus, both publicly and privately, the suggestible suspect comes to agree with the account offered by the interrogator, even though it differs from their own memory for events. Some individuals would be more susceptible than others. Gudjonsson and his colleagues have shown that interrogative suggestibility is related to a poor recall of the original event, perhaps because of the intoxication at that time. Low self-esteem, low intelligence, high emotionality and anxiety, and a high need for social approval. The overall picture which emerges is that situational cues, interrogational pressure, and the suspect's characteristics can also interact and increase the likelihood of a false confession. Psychology in the courtroom. The psychological study of courtroom processes covers a great deal of ground, spanning both criminal and civil courts, and incorporates diverse areas of law, including juvenile and family law, mental health law, discrimination law, and competency to stand trial. However, the study of jury lies at the heart of the area of forensic psychology. The jury is a natural topic for psychological research. Jury must listen to and evaluate evidence. Each juror must formulate their present opinion regarding the accused guilt or innocence, and then the jurors meet to discuss the evidence and real collective decision. The cognitive and social processes involved in coming to a decision are critical for justice to be done, but there is a problem in conducting jury research. For obvious reasons, it is not ethically permissible that the studies of jurors are conducted during the trial, nor in some jurisdictions is it possible to interview and seek to debrief juror after a trial. Thus, a great deal of knowledge of jury and juror behavior comes into from so-called mock jury studies, in which controlled simulation of trials are conducted and the mock jurors are closely observed while key variables are introduced into the proceedings. Extra evidential influences. The evidence presented in the courtroom should inform jury decision making. However, there is a concern that jurors can be influenced by various extra evidential influences, including pre-trial publicity, witness confidence, and their own and other jurors' sentiments and prejudices. Pre-trial publicity. In typical studies, the decision of mock jurors exposed to publicity are compared with those of other mock jurors who are not subject to such influence. Thus, mock jurors may be shown newspaper cutting containing details about, say, a defendant's criminal record or other reacted confession. When compared to mock jurors who read newspaper stories which did not contain the blasting details, the exposed jurors are more likely to return a guilty verdict after a mock trial. In real life, judges can interact with jurors to ignore partial publicity. But this is a publicity easier to say than to do. In practice, the selection of jurors not exposed to the pre-trial influence are optimum strategy to select a fair jury, although once again is probably easier said than done. Witness confidence. In a highly confident witness, is a highly confident witness more likely to be believed by the jurors than an uncertain witness? The experimental evidence certainly suggests that the mock jurors are more likely to be persuaded by testimony from a confident witness and so return a guilty verdict. Conversely, jurors place less credibility on the testimony of the less confident witness, given that, as noted previously, witness confidence is not always a reliable index of accuracy. A belief is a positive relationship between the confidence and accuracy is not necessarily a good thing. Interpersonal perception. Are jurors influenced by emotion, sympathy, prejudice? For example, the perceived physical attractiveness of the defendant can lead to favorable outcome, but an attractive defender with no justification for their offence may be seen in a more severe light. Similarly, defendant of high socio-economic status may be seen as less blameworthy for their offence, while a gender blast may suggest the females are less likely to be forced